Hello, brilliant minds. I'm your host, Miles, and I'm happy to welcome you to another sharp edge episode of Xraised, where knowledge meets inspiration in the intricate dance of industry evolution. I'm back here to raise the bar by spotlighting an innovator redefining the world of law and tech. This one is for the legal eagles, the technophiles, and the skeptics. And if you're all three, well, buckle up. Because we're bringing back to the show our favorite award winning barrister who's cracked open the legal research black box and rebuilt it from the ground up. She's a published author, an academic, and now one of Australia's most visionary legal tech CEOs. From Harvard Business School to high stakes litigation, and now to Sydney University's radar, she's worn every robe the profession offers, and then stitched AI into its fabric. We have the privilege to have her once again here to tell us more about her mission, delivering AI powered, evidence backed legal research that levels the playing field for lawyers and champions access to justice for all. So, here's the unstoppable co founder and chief executive officer of MiAI Law, Laina Chan. Hi.
You're very funny. You're really good with words. I can see you knitting the whole thing together.
Well, that's what you said in our
Anyway,
previous episode, so I just used them.
it's great. Anyway,
Leveling the
happy to be
playing
here.
field. I
Mhm.
love that. Well, you look great as usual, Lena. You've already made an indelible mark. But most of us know that now you're also reshaping its very infrastructure. So let's get to know more about how your bold, complex, and game changing AI powered advocacy is redefining legal excellence with a touch of logic, a dose of trust, and maybe a little sass from the machines. So you've spent decades mastering legal nuance, Lena. But how did your frustration with the inefficiencies of traditional research become the spark behind my AI Law's creation?
Well, it wasn't so much the inefficiencies of legal research, it was my inability to have instant recall of my own intellectual property.
Okay.
That was what sparked it. But that's what all the large law firms are doing. They're all paying for on-premises solutions to have AI come in and mine their own data to retrieve their own intellectual property. But then my co-founder, who we're not together with, we're not together anymore, but he refused to basically deliver what I wanted. He basically likes to just do whatever he wants. Anyway, he refused to deliver what I wanted, which was very simple, which is what all the law firms did. And actually, thank God we didn't do that because that was such low hanging fruit. And he said, well, in order to do that, we need to solve the legal research problem. But that's not true. We could have solved the other problem. We didn't need to do legal research in order to be able to mine my own intellectual property. But obviously, he had ideas of his own. But it's worked out for the best because what I have done now without his help is to be able to deliver precise evidence-based legal research where we've revealed the black box and
Yes.
we're delivering the biggest increase to productivity for lawyers since I think since Casebase. Since Casebase came along and provide the one-click solution to tell you what all the other cases, subsequent cases have handled precedent.
Yeah.
And now what we're doing is not only that, not just telling you what case, but actually being able to read what those cases have actually done and being able to handle those that information to craft the research memo.
Mm-hmm.
That's what we're doing. So it's from manual noting up to case-based, and now the next step
Mm-hmm.
is case-based to this. I think that's the kind of massive leap in productivity that I am delivering to lawyers.
Yeah. Well, that's such a profound insight, Lena. It's not that the law lacks clarity, but that the human brain has limits. And that's why
Yes,
you've created my AI law. And I think what you've done with it solves inefficiency. You've designed a recall engine for legal intellects like you. And you've essentially turned compromise into a choice, not just a necessity. And we know lawyers are trained to read between the lines, but AI can miss the nuance if not properly designed. So, could you tell our audience how My AI Law goes beyond keyword matching to truly grasp legal ambiguity, especially in gray area cases?
Well, it's not my job. I don't think it's my AI law's job to do that. But it is my AI law's job to be able to track that there is ambiguity in the law and to tell you how that ambiguity has been handled by the courts and the arguments that parties have put in relation to that ambiguity. So, for example, yesterday I was having breakfast with a judge. He's a good friend of mine, and he's a really good friend of mine, actually. And he said to me that I said, oh, I've been able to extract the ratio from all the cases. And, he was one of the leading silks in Australia, and he's always in the newspapers. The press just love him. And he said, well, you think you've been able to extract the ratio. That's what you think. I go, okay.
Mhm.
And then he said, well, because you can get 20 lawyers arguing about what the ratio of a case is, and all 20 of them would be right. And I go, really? I don't think so. Anyway, he said, you only think you've been able to do that. That's just your personal opinion. I said, okay, well, let's just test the model. Give me a case where you think that the ratio, which is the key principle of the case, is ambiguous, and
Yeah.
we can see whether my AI can extract it from the case, right? So
Mm.
he named the case Cadelfer and State Rail Authority, which is so much ink has been spilled over the judgment. It's been the cause of so much court cases, etc. And the key principle in that case that everyone agonizes over is when can you look at surrounding circumstances when you're trying to work out what a contract means? And the Chief Justice Mason said at the time, you can only look at surrounding circumstances if it is the term or the clause is ambiguous, right?
Yeah.
And it seems
There.
simple,
Yeah.
but we don't actually know what that means. It's so funny, right? I'm sure he had no idea when he just wrote that you can look at surrounding circumstances when there's ambiguity, that he didn't realize that we would just have forevermore, for years and years, tens of years afterwards, we'll all be sitting there going, what on earth does that actually mean? So I downloaded a case that had all the subsequent treatment embedded into the law report. So it was about 170 pages, but the law report itself is only about 80 pages. Then there's 80 pages worth of subsequent treatment of the various paragraphs. It tells you how subsequent cases have treated a particular paragraph. And so I ran it through the case summarization, and it didn't say under Justice Mason
Yeah.
that what he had said that, but it did say under the doctrinal explanation, it did say that you can only look at some surrounding circumstances if there's ambiguity, and it said it was doctrine, right? And that's actually true because it has gone through and set out all the subsequent cases, and everyone has said, well, that's the doctrine, that's the doctrine, that's the doctrine. And so then the judge said, well, it hasn't, okay, fine. In the beginning, he said it's missed it. I go, well, no, it hasn't missed it. It's here, but it hasn't, it's just treated it as this doctrine. It hasn't put it under the judge's name and the paragraph references to say it's the ratio. And then I said, okay, well, let's just put the native judgment in, the one that doesn't tell you what has happened in the future. So we ran the native judgment through the model, and it identified under Chief Justice Mason, this is what he said, that you can only look at surrounding circumstances when there's ambiguity, when it's, ambiguous. And
Yeah.
it said that that was the ratio, and it gave the paragraph referencing. And then Rob said, okay, so it's picked it up, but it hasn't like analyzed the ambiguity. And I said, well, that's not the job of a case summarizer to tell
Yeah.
you
Uh-huh.
that is ambiguous. I haven't created an algorithm to then kind of say this term is ambiguous, that term is ambiguous. I haven't done that because that's the job of the lawyer.
Yes.
That is the job of the lawyer to do that, to look at that. And then you can ask it a second research report. You can ask it, track through how that,
Mm-hmm.
in what circumstances can you look at surrounding circumstances? And then the model will go through and it will extract all the cases, subsequent cases that have looked at it. And it will tell you how it has been handled. but it's not analyzing. It's not, how do you put it? It's not actually grasping legal ambiguity in gray area cases, but it can tell you how courts have treated
Uh-huh.
gray area cases and ambiguity. So, for example, last week, as a result of meeting with all these lawyers last week, they wanted me to develop a contract review feature. And that was something that I wasn't going to do until way later, but they convinced me that I should do it now and we should do it from first principles. So
Yeah.
that afternoon, I went away and I wrote the algorithm and I told it to do various things. And one of it was to do a defined terms audit. And that was as a result of I consider Australia's best senior counsel said, make sure you get it to do a defined terms audit to see whether there's ambiguities and circularities that arise from how the defined terms have been used in the contract.
Mm-hmm.
And then it said, then I wanted it to then look through the case law to see whether any of these clauses had been the subject of litigation, had been considered to be ambiguous, etc. And
Mm-hmm.
so I did that whole thing. I showed it to some lawyers. I showed it to Noel Hutley, etc. And, they gave some feedback. And so in that way, the model was able to identify whether there were ambiguities, not because it had worked it out for itself, not necessarily, but because it was able to look back in history to see that certain clauses had been the subject of judicial consideration and they had been, and had been considered to be ambiguous in the past. And then it then suggests alternative wordings, which my in-house counsel says is not very good, but that's okay. I mean, it's just a suggestion. The lawyers have to do their job too. But
Yeah.
at least we've gone through and we've identified when there has been circularity and redundancies and when the terms are ambiguous and when they should be the subject of amendment. And so I go through, we do a defined terms audit, we do a deep risk and legal analysis, and then we
Mm-hmm.
produce the report.
Yeah.
But we're not grasping itself. It's not grasping itself that it's ambiguous. It's just looking historically.
Mm-hmm. And that distinction is crucial, Lena. My AI is not actually going to be there to think for lawyers.
No,
It's going to be there to clear the fog around what's already been
that's
written.
right. Absolutely.
Mm-hmm. And it's
And
for the
guide them
lawyer.
and point them in the right direction.
Yeah, and it's for the lawyer to look at the available information and strategize. Then my
Yeah. Yeah,
uh-huh.
sorry.
Yeah, sorry,
So
go
I
ahead.
sent I sent one contract review report to Noel Hutley, and
Uh-huh.
then his response was because it identified so many circularities and redundancies in the way the clauses had been drafted. And
Mm-hmm.
then he said, "Wow," he goes, just as I suspected, don't clean up all the contracts or I'll go broke." Just pretty funny.
Well, it's good that my AI is here to identify key issues and principles
Yes,
and
key issues.
right.
And
And
then
I
it's for
assume,
the lawyers to clean it up.
yes, and I assume that's a leap most AI products now in law haven't made yet.
No,
That's
I doubt it.
uh-huh.
Because I've written the one algorithm and it covers every single subject matter area of law.
Mhm. And legal tech adoption isn't just a technical issue, it's often cultural. So, what have been some of the most unexpected lessons or maybe barriers in getting lawyers to embrace my AI law as part of their daily workflow in the future?
Well, I think I mentioned this in the last episode. There's some protective behavior going on.
Uh-huh.
And then there's some firms who have just recently adopted Harvey into their workflow who kept telling me very proudly that they have Harvey, but Harvey is not our competitor. Harvey is helping with the workflow, I think, apart from research. For their research, I think they are just a wrap around OpenAI, and they refuse to be benchmarked. Their research outputs, they refuse to be benchmarked. So they allow themselves to be benchmarked on other aspects of their product, but they refuse to be benchmarked against for research. And in fact, one of my mentees, her firm has Harvey in their workflow, and the partnership has told them that they are not allowed to use Harvey for research. And so we're just not competitors. So it's just quite amusing when partners from big law firms do not even want to look at our product because they tell me that they have Harvey and that they're going to do a show and tell. I go, that's great. Let's do a show and tell and let's see who wows the other person, right? Because we're just not competing with Harvey. We're in completely different spaces, you know? I mean, yes, it's legal tech, but what we are targeting and the efficiencies that we're trying to bring are not the same as what Harvey's doing or what, I mean, yes, definitely
At
not
least
what
now
Harvey's
that's
doing.
clear.
Hmm?
At least
And
now
there
that's very clear.
it's very clear, especially when they refuse to be benchmarked.
Yeah.
So it's dangerous because everyone knows, and OpenAI, they come out and they say that their language models are not to be used for law or medicine because they haven't been trained or specifically uh, taught
Uh-huh.
how to deal with the law. So they've read everything on the internet. Of course, they've read everything, but then it's just only working on probabilities and inference. There's no specific legal brain or legal mind behind it directing the model on how to behave. So it's basically like a
Yeah.
litigant in person, which is very dangerous. So there's basically people out there who know a little bit about the law. It's kind of the Dunning-Kruger effect. So they know a little bit about the law and they think they know everything. And that's really dangerous. And that's why we cannot sell to anyone but lawyers,
Yeah.
because my AI in the hands of the general public is dangerous because they can completely discounted the value that our legal experience brings to the table.
Mhm. It's less about AI versus lawyer again, and more about how did we ever work without this? It's gonna be a norm for the for all the lawyers. And
Yeah. Once the education piece is addressed,
yeah.
then it will make lawyers productive from the first day they start at work. They
Right.
can start weighing in on strategy and, the more interesting work, rather than being
Mm-hmm.
sent off to do the grind. Who
Mm-hmm.
wants to do the grind? You mean it's just killing. And it's so
Right.
funny when, I hear at the conference lawyers who are again behaving in a protective way saying that they want to do the grind because that's how they learn. But I don't think you learn by doing the grind. I mean, you have to learn how to think, absolutely. But if
Mhm.
you are trawling through 50,000 documents to find those needles in the haystack, is that helping you think, or are you just behaving like a robot? Just quickly going through to look for search keyword terms, etc., and then culling it to the key bundle of documents. It's only when you go through the key bundle of documents that's when you're really starting to think. And when you're doing all the research and all the grind, you definitely need to learn how to think. You do
Yeah.
need to learn how to think and understand how the law works. But that's a
Mhm.
problem that the universities have to learn. They have to learn how to teach the students how to think.
Yeah. We gotta stimulate their brains. And so, moving along, you've operated across the legal spectrum, Lena, from clerkships to litigation to startup leadership. What has surprised you most about how the legal profession is or isn't adapting to AI?
Well, I was when the idea was just an idea, and I spoke to courts down in Victoria, and they would say, "Oh no, we can't do this," or "Oh no, actually, maybe they would say, "Can you help us? Can you help us with preparing draft judgment so that we can use AI to help just prepare the first draft, or we go through all the legal submissions and the evidence to set out the issues, the evidence, the submissions, the arguments of both sides, and obviously it's up to the judge then decide what they're going to do with it all, because that is always the job of the legal brain. And
Yeah.
so I met with judges last week at the federal level and at the state level, and they wanted that.
Yeah.
So, and I thought I was just going to see them to see what their attitude to AI was, but they actually wanted to know if we could deliver a product that would help them get over the grind.
Mm-hmm.
Everybody wants to get over the grind. And then I met with lots and lots of lawyers from law firms. And again, once they saw the product, they wanted it. And one firm said, when you sent me the case summaries, we were thought, oh, this is very interesting. But then when I sent them the deep research reports, they said, oh no, when we saw those, we knew that we had to be in. This is really impressive. And we knew that we just have to be in on it. And basically, that seems to be the message because it's accurate, right? I mean, even the skeptical judge, he's going to be beta testing. I mean, the courts
Yeah.
can't afford, he thinks the court can't afford to pay for all this. I don't know. But I said to him, what happens if the Victorian courts are on board and then some of the federal court, well, one, there's two. For some of the federal courts are on board, then what's going to happen? And then he said, well, then everyone will have to catch up. But
Mm-hmm.
then he said, I can use it to just test the submissions of the parties, to
Mm.
test whether what
Interesting.
is being said to him is actually correct.
Yeah. And then that saves time. And that speaks volumes when the courts themselves ask for help drafting judgments.
And they also say, if we can run this case summarization in court every time a counsel mentions a case at us, we've never heard of it. We can
Huh?
easily, quickly run it through the case summarizer, and then we can see for ourselves whether the case is actually relevant
Yeah.
or not relevant to the argument that's being put to us.
Mm-hmm. And that's not just a sign of acceptance. It's a validation of my AI's deep functional relevance, I guess.
Yes, and then that particular judge said to me, and you've even been able to extract the ratio. How did you do that? He goes, many lawyers can't do that, including judges, but you've even been able to do that. I mean, I showed him examples.
Well, you're
So
you're a top barrister.
not everyone can do it. Well, not everyone can do it and actually be able to reduce it to code,
Mm-hmm.
which is the amazing thing.
Okay. So last but not least, Lena, and I don't want to miss this because trust and data privacy are cornerstones of legal ethics. How is my AI law navigating the tension between innovation and compliance, especially with sensitive uploads and evolving principle or privacy frameworks in play?
Well, we have two levels. In the beginning with the legal research. You can upload your case, you can research. There's nothing sensitive about that. I don't think so. But still all your data is kept on our servers and it's all encrypted,
Mm-hmm.
etc. And then we have to send it to NVIDIA for inference and we have to send it for inference. So we have to trust that NVIDIA is not going to use our data. They say they're not going to, and they're not going to use it for training. And you have to believe them because, oh my God, how on earth can they afford to store everybody's data? I mean, that would just be so expensive. And then secondly, we NVIDIA says that the information that is sent to them for processing is encrypted in transit and at rest. That's what they say. And
Mm-hmm.
then on top of that, we encrypt everything ourselves when we store it. And there is one other feature we can do, at least for contract reviews, we can anonymize the contracts before we send it to NVIDIA for inference. Because so that's one thing. And then otherwise, if you're very rich, if you're like a large law firm or if you're the government, etc.,
Mm-hmm.
then I'm actually working with Hewlett Packard
Okay.
to they're delivering on-premises solutions to already, I can't remember which police force it was, and large law firms, I don't know if it was the Victorian or Queensland Police, to help them mine their own data and retrieve information, etc. And they're doing this for large law firms. They're also doing this for the Thai judiciary. But that's only one part of the solution. So you're doing it on premises. So that means that these firms and government bodies have their own set of NVIDIA servers, the H100 servers. So the data never goes outside. It's in a closed system. So it
Mm-hmm.
doesn't go anywhere, right? So it's all within on premises at the law firm or in the cloud, wherever it is.
Mm-hmm.
And so he says that our model would then sit within the architecture that they have, the standard architecture that they're using to deliver the on-premises solution, so that when they can mine their own data, which can provide context for our research, and then all our research is being done on premises on their own dedicated
Mhm.
set of H100 service, and that way all data privacy and everything is maintained.
Yeah, impressive. I mean, with HP and Nvidia, that's a gold standard approach. And in a field where trust is currency, encryption and data control aren't optional, they're really foundational. So, I mean, HP and Nvidia, again, backing the vision. It's clear that this
There's two other data providers as well who
Mhm.
want to partner with us, but I haven't yet followed that up because I needed to make sure that we had a working product. But I already had a relationship with the APAC head of HP because we met. He'd reached out to me and we met at the San Jose NVIDIA GTC conference.
Mhm.
But now I have to reach out to the NVIDIA Asia, Australia, New Zealand head for the client director.
Uh-huh.
He's working with me too, and he's already reached out to two other data providers, and they want to partner with me as well. But I think now I'm ready to talk to them. But I just
Yeah.
wasn't ready before. But I did say to HP, but we don't have an exclusive relationship, because there are other data providers that also want to work with me. And he goes, of course.
Yeah, but with
I
those
cleared that.
heavyweights backing the vision, Dana, it's clear this is a legal infrastructure in the making. My
Yes.
AI seems to be smart, ethically engineered, and it's a
Yeah.
blueprint worth replicating. I
What do
mean,
you mean by replicating? You can't replicate as we're getting,
I
we're
said
going
worth
to get.
worth replicating.
Yeah.
Well, if they
Yeah.
can, if they have another, what if they have a Laina Chan, which is
Well, that's why we're filing our patent application very shortly.
well, it's an innovation, but
Because we know that they're going to come after us.
mhm,
So we need to
for
get
sure.
ourselves some protection.
Uh-huh. It's like an innovation back with expertise, experience, and it doesn't
Yeah,
come at the cost of client confidence. It builds privacy into the platform's core rather than treating it as just as a plugin, right? It's a partner. It's like they're
exactly.
it's like they're your partner. I'm
No,
going
that's right.
to
So
your
that's why MiAI Law, we call ourselves the legal AI research partner.
uh-huh. Well, thank you once again for sharing how you're reshaping the law landscape, Lena, making it more human, ironically, with the help of smart AI. Thank you.
Thanks, Miles.
All right. If you've ever wondered whether AI could be both a sharp tool and a trusted colleague or partner in the legal world, Lena just answered with a confident absolutely. And here's the citation. And for those ready to experience My AI Law firsthand, head over to myai.law or simply tap on the link below. Thanks for being with us. Lena and I will catch you again in our next episode. This has been your host, Miles. Stay focused and inspired with Xraised.